Thank you. Thank you, Mr. Timba. Good morning, ladies and gentlemen. Molweni, sanbonani, niphilile. Hayi molweni. Ngiyabonga. Yeah, now sesifikile ke Mthatha, sesifikile. Igama lami Mnumzana Zondi. I am the Acting Executive Education and Communication at the Information Regulator. I would like to appreciate your presence today. Thank you for fighting the cold and attending the Information Regulator's Stakeholder Engagement Breakfast. You are all most welcome. Our program is not going to be very long. However, we do encourage that it be a very engaging program because we are here today to discuss all things POPIA and PAIA. POPIA, personal information, vast engagement yourselves as able to improve compliance with these two legislation and so people can exercise their right to privacy and their right to proceed, colleagues. I've been requested that we do try and exercise condition 2 of POPIA, and we request your consent because we are going to be recording program and we'll also be condition 2 consent. We want to be voluntary, so we don't take pictures of you, then you cannot be in attendance. So we want it to be voluntary, and this is how we're going to do it. On registration, we did inquire if you do not mind being photographed or take that you would not want to be photographed, and in that instance, we then gave you a red lanyard. So in your bag, you would have a red lanyard. We do request that you do put it on if you do not wish to be photographed or a video taken of you, because we are profiling our program today and we will be profiling it on our digital platforms. So if you do have a red lanyard, we do request that you do put it on. If you do not have one, our colleagues Tejo just walked in, Bonkos is there at the back, please do request for one so that there is a very special number this year. And I think I say that also because this is actually our 10th provincial roadshow. And we are back here in the Eastern Cape and doing what we do best to encourage members of the public to exercise their rights and promote compliance and enforce compliance in terms of POPIA and PAIA. So this is our 10th visit. But another key milestone for us as the Information Regulator, we are actually celebrating 10 years of our existence. We were established in 2016 and this year we are 10 years. Yes, please do give us a round of applause. Thank you so much. I want to just give a quick apology, colleagues. We're supposed to have our members here today, which is our commissioners, but some have taken leave and some are having international work commitments. So I'd like to apologize for our chairperson, Advocate Tlakula, as well as Advocate Strum and Mr. Gwala. But in that same breath, I would like to maybe just quickly introduce our executives and senior management team that are here today, who you will be asking all the hard questions. So I would like to just introduce our Chief Executive Officer, CEO, Mr. Mosalanyane Mosala. We also have the executive, Mr. POPIA, Advocate Boikanyo. We also have our acting executive PAIA, Mr. Mukelani Dimba. We also have our chief information officer, which is Mr. Thando Luyaba. We have our senior manager complaints and investigation from POPIA, Ms. Advocate Nosipho Zikishe. And we also have our senior manager IT analysis, Mr. Mazibu, Langitemba Mazibu. And we have the team with us as well. Thank you so much, colleagues. All right, colleagues, we do have our program on our screen. Please do scan the QR code to access our program. If you do have any challenges, please ask your neighbor to assist you to access that program. We're trying to go a little paperless. Without wasting any time, I would like to invite our CEO, Mr. Musalanyane Musala, to give us an opening welcome address and just give us the purpose of why we are here today at Mayfair Hotel, but basically also why we are here in the Eastern Cape province. If you can just welcome him with a round of applause. Thank you.
Good morning, everyone. I stand here on the protocol established by the program director. I don't think the echoes are helping, but I'll try my level best. Just in the interest of time, I just want to say one thing just on a very light moment this morning. Working with lawyers can be a very big problem because sometimes they're too serious. So for the time I've spent at the regulator not being a lawyer, I've tried my best to make lawyers to smile all the time, to laugh all the times. So I like these light moments because it helps if you have lawyers in the room. I'm somebody who's very, very, very old. Very old. I'm actually retired. I'm not supposed to be here, but the regulators asked me to stay on until December of this year. It's a matter that I've discussed with the regulator. So I've been working for 44 years. At the end of this year, I would have worked exactly for 44 years at the end of December. 4 years, not months, 44 years. But there's one moment that will always, always stand out in my life of work. Just 1 year before I started working, I visited my brother who lived in Cape Town at that time, and he was working at the University of Cape Town. I had completed my teacher's diploma and I was looking for work, but it was not easy to get work immediately. So I went to visit my brother who lives in a place called Gugulethu. There's a place called Malunga Park in Gugulethu. Those of you who know Cape Town. I went there, and because I was still very fresh from college and still very young at that time, very tiny, I met friends. I made friends easily. It was easy for me to make friends. And I met this friend, and I was from the Free State where people speak Sotho, Southern Sotho. So I had not had any knowledge of any isiXhosa word, except at the church where people would translate, when the preacher. And this friend of mine that I met started teaching me a few words because I needed to navigate my life around Cape Town. So I would need language. And what happened is that the first thing he taught me was, when you greet people, you must say, Molo. I said to him, I need to greet people now. What do I say in isiXhosa? He says, you must say, Molo. I said, no, Jim. I can't say mall, it's in the evening. He said, no, you're out of order. When you're in the Eastern Cape, it's mall in the morning, it's mall during the day, and it's mall in the evening. So I'm reminded by that when Nomzamo stands there and says, Molweni, and you respond. Yes, I'm reminded by that. So good morning, colleagues, and thank you very much for attending this stakeholder engagement session. Who are we? We are the Information Regulator of South Africa, and we are established in terms of Section 39 of POPIA. We are a juristic person, and you can read the rest for yourself in Section 39. I'm not going to go into that. Divisional heads will talk about our mandate, They will talk about how they carry out and implement the mandate. They'll talk about your responsibility with regards to the mandate. So I'm not going to go into really the work of the regulator as such. I'm going to touch on this program called Dikopano. It's a program that we coined I think after 2021, if I'm not mistaken, Mr. Timba. Around that time, we coined a program called Dikopano, meaning Izimbizo, where we meet with our communities, where we meet with our stakeholders, where we have discussions about the role of the regulator, but the roles of different stakeholders and the roles of members of the community. And we started in Soweto. Our first visit was in Soweto, but we made the decision that from Soweto, we will travel into the rural provinces of this country and touch base with all our people and talk to them about the two rights that come from the Constitution, which the two pieces of legislation give effect to. So we coined a program called Dikopano, and we started engaging. Nomzamo is right, Ms. Zondi is right when she says this is our 10th engagement. We visited all the 9 provinces, including this province, in our first set of engagements. We are now starting the second set of engagement, and we are starting here in the Eastern Cape again. We are on the other side of the Eastern Cape, in Gqeberha and the surrounding areas. I can't now remember the year, but I think it's 2023. And we had a Dikopano session. Our Dikopano program is a program that takes the whole week. When we come to a province, we actually start coming on a Monday, and today is the last day, but it's not the least day. It is a day where we meet with responsible parties, and the executives will tell you who are responsible parties, and I think that everyone sitting in the room here is a responsible party. So day 5 of our program is the end day, but it's a day where we engage with people and organizations who collect and process information, who hold information which people must access. This is a day in which we engage with you. So today it's about that. Day 1 and day 2, it's normally about community engagement, where we go to the taxis, we make people aware about our legislation, we make them aware about their rights. So we are out in the communities for day 1 and 2. On day 3, we meet with the Office of the Premier, which we have done, where we really are touching base with the Premier to say we are here, officials in the office earlier during the preparatory stages. But on that day, we meet with the Premier to report our presence, but also to raise issues that worry us, issues of success in the province in terms of our engagement with the province. So we have met with the Office of the Premier on Wednesday, and some of the reports that we have presented to the Premier will be presented in this meeting, just to make you aware of what we have said to the Premier. And then that day we went down to Bechwana village, where we go to meet with a particular community. And we first teach them about our act, our laws, their rights, their responsibilities, and we engage with them. They ask us questions. Well, unfortunately, yesterday, we went there at the wrong time because it's around election times. So the issues that were raised there, majority of them had nothing to do with what we went there for, but they had to do with the work of the municipality. But they had indirect impact on our work because issues of access to information, it's very important to service delivery. If people do not have access to information, that enables them to know where the municipality is with its program of service delivery, improvement. That part of access information does not enable people to exercise their right. So those questions, although they were about water, about electricity, about very many other things relating to service delivery, they had an element of access to them. But they also had an element of protection of personal information because some of them complained about Abogogo's money has been taken unscrupulously by people who rob them their pension and stuff like. So all of those, and they sometimes are enabled by some of our colleagues in the public service in some instances. So they have everything to do indirectly with POPIA. So even though the questions were mostly about service delivery questions, they had everything to do with access, they have everything to do with protection. So we met with the communities, we have heard them, we have answered their questions. There weren't too many questions. But we are here this morning to meet with you as responsible parties. And in terms of PAIA, Mr. Dimba, they are not called responsible parties, public bodies and private bodies. So from where I'm sitting and from where I'm operating as the CEO, I'm not going to talk about what Mr. Dimba is going to talk about. I'm not going to talk about what Advocate Bikani is going to talk about. I'm going to talk about my responsibility and the responsibility of the CEO of the Information Regulator is in terms of Section 55. If you read Section 55, it talks about, we don't call them accounting officers, we call them information officers. Why do I now forget them? Information officer. And that's perhaps the very reason that I must really retire. Information officers. Heads of department, CEOs of institutions, people who run small bodies, law firms, and so on and so on, are information officers. And their first responsibility as information officers is to register with the regulator. What the Act says. If you can try and mute the computers, it might help. Thank you. So if you are an information officer and you are in this room and you process personal information and you provide access to information and you are not registered, you are breaking the law. Or if you are representing a department, a body, an institution, and your CEO, your managing director, your head of department, any other person who's an information officer, and your institution collects and processes personal information of people, your institution has information that people can access to be able to exercise certain rights, and you are not registered, you are breaking the law. So we may as well, Advocate Bikanyo and Mr. Dimba, start issuing letters in this room. We may as well having people who are not complying in this room. But perhaps charity begins at home. And the question would be, is the CEO of the Information Regulator as an information officer registered? I don't want to answer that question. I want you to check for yourself. So those who've got laptops, the CIO will tell you, will give you where to check whether we are registered as a regulator. This is very important. So our concern, our main concern is that responsible parties, especially those who are accounting officers and information officers, are not taking this role seriously. The second point is we have what we call annual reports in terms of PAIA, which we have to make them public in our own annual report to indicate how people have access information and how they've been allowed to do so by different institutions. You'll get statistics on how we are doing. But when we briefed the Premier the other day, I think we were excited that the provincial governments are complying. And that's the good news. But the municipalities are not complying. And the municipalities are more than any institution of state. Very, very close to our people. And it's a worry for us. I think out of 38 municipalities, they say I will give you statistics, very, very few are complying. And it's a worry for us. So these are the issues that colleagues of the regulator will go into details to explain. And you will have an opportunity to engage and ask us difficult questions about them. But I want to conclude my opening remarks by saying that, chapter 2 of the Constitution is such an important chapter. And I don't think people take that chapter seriously, generally in South Africa. Because it's a chapter that balances the power of the state to the rights of people. And I'll give you an example, and I may sound controversial, but I'll give you an example anyway. That the state is well within its right to come up with measures. You must obey traffic lights, you must not vandalize, you must behave in a particular way, and it will go on and on. Ministers will from time to time be on television telling how the state will deal with people who are not obliging and so on and so on. But there's less emphasis on the rights of people. And chapter 2 is meant for that. It's meant to balance the power of the state so that the state does not wake up one day and say you will not march, we are going to shut down your social media platforms so that you are unable to organize yourself. It will be a sad day in this country. So bringing it home to the regulator, the right to privacy as it relates to the protection of personal information is an important right. Because people today take your picture, they share it, they put it anywhere else. Organizations just collect your information. When you drive into buildings, state buildings, people take your ID number, they scan your ID, and they hired security companies. We are not sure where does that information ending when the security the company does no longer have a contract. And that information may as well be information that is overseas, that people are selling it for other business. So the right to privacy as it relates to the protection of personal information is an important right. So is the right to access to information. Just yesterday, Mr. Jimba gave a practical example of people who needed water. And they were toy-toying, and they wanted the municipality to give them water. But they were not aware that there are plans to do that, simply because they could not access that information. Access to information is no longer about accessing your birth certificate at Home Affairs. It's access to services. It's a matter of life and death. So these rights that are in Chapter 2 are important rights. So as responsible parties, we are joined with us to ensure that these rights are realized. And that's what this session is about today and this morning. And I thank you.
Thank you so much, CEO, for reminding us that we are the vanguards for information rights, and everyone in this room can assist us to ensure that everyone is able to exercise their rights, their right to privacy and their right of access to information. I think it is important for us to acknowledge the Office of the Premier for assisting us in coordinating our provincial roadshow here in the Eastern Cape. And I just want to recognize Mr. Fortune, the Chief Legal Advisor in the Premier's office, and please do relay our gratitude and appreciation for the support that we received to be able to coordinate these sessions in the province. Thank you very much. And we can give the Office of the Premier a round of applause. Thank you. All right, now for those that didn't succeed in scanning and getting the program, we are going to have the next three presentations. I would really urge that you do take note of the presentations because we'll only have an engagement at the end of the three presentations that we'll have. We're firstly going to have a presentation on POPIA, the Protection of Personal Information Act, followed by the Promotion of Access to Information Act, PAIA. Then we are going to have a live demonstration of our digital platform and services that we have available to you. So without wasting time, I would like to invite Advocate Boikanyo, who is the executive responsible for POPIA. We can welcome him with a round of applause. Thank you.
Good morning to all the colleagues. Let me start off by CEO. Do you say Molo? So let me say Molo and Molweni. Let me start off by acknowledging the leadership first of the Information Regulator under the leadership of the CEO, Mr. Musalanyane Musala, my colleagues on the executive team and the senior managers that are here. The team from the Information Regulator that put together this event. But most importantly, colleagues, let me start off by acknowledging all of you. What I've come to know over the years about the Eastern Cape is that it has a lot of warm people. They are said to be people that love people. But there's one thing that I've learned in the last 2 days that we've been here, that the people in Eastern Cape don't like waking up early. So I want to put that up front and say that that's what I've picked up. And at 8 o'clock, which is the time that we were scheduled to start, I think there were only 2 of the colleagues that were here, or 3 of the colleagues that were here. So that's something that I've just learned about the Eastern Cape. In Gauteng, at that time, we were already on the freeway and it's bumper to bumper. And we are heading towards our respective jobs. I'm going to try today not to be too controversial. I'll try. I don't promise that I'm going to succeed. As part of the work that we've done, we over the years we have done quite a bit, and we plan to give you when we leave here. We plan to have given you the roadmap that is going to assist you with compliance with the provisions of the act that we are responsible for, which is POPIA. We can go to the first slide. The CEO has already really laid the carpet with regard to the work that we do. And the CEO has told you, we can go to the, yeah, thank you very much. Our act, you will see that our act is Act 4 of 2013. So which effectively means that if you count, there's been 12 years of POPIA. But we were not established as a regulator at that time. And the reason why the CEO is saying that we are celebrating our 10 years is that we started 10 years ago with the members, a few members that were here, that were appointed at that time, and then started putting together the regulator. But even at that time, we had a challenges because our enforcement powers had not as yet come into effect, and our enforcement powers only came into effect on the 1st of July 2021, and that's really when we started doing the work that we are doing as a regulator. We can go to the next slide, madam. And in that time, I decided just to quickly look at some of the headlines that we've made over the years. You can see that Information Regulator signals tougher POPIA and PAIA enforcement. Information Regulator exposes POPIA violators as data breaches mount. South African Police Services and IEC to be fined of 5 million. 5 million. Now, what is the purpose of our session? Amongst others, our session today is aimed at ensuring that you don't get into trouble as public bodies and private bodies that have to comply with the provisions of POPIA. Now, I want us to look at some of the myths about POPIA. Most of the people, when you engage with them, they say, well, no, that POPIA is it's not about us. It is about cybersecurity. And it's IT that has to be responsible for that POPIA. And there are others that say, no, this is just an IT project. Now, that myth has got to be dispelled. POPIA applies across the entire organization, in any organization. It's a legal and operational compliance duty, not just for IT or a cybersecurity matter. So it applies to all businesses. We can pass the two slides and go to the statistics. I felt that just to start off our presentation today, I must just lay the foundation and look at where we have come from as an organization. And the reason why I'm doing this is because it impacts on you as a responsible parties. Because remember that the complaints that we get are in relation to responsible parties. So when people complain, they would complain because there's a transgression of POPIA insofar as the processing of their personal information is concerned. Now, in the 2022-2023 financial year, we started off with 951 complaints. They then increased in the 2023-2024 financial year to 1,044. They then increased in the year after that to 1,355. In the 2025-2026 financial year, they increased to 1,824. And in the 2026-2027 financial year, we are sitting now at 908. These are just the complaints. Advocate Zikisha was introduced to you. She heads the complaints and investigation subdivision. There are some assessments that we've already conducted. We have conducted to date 35 of these assessments. And in the 2022-2023 financial year, we had 5. In the following year after that, 2023-2024, 5. 2024-2025, 14. 2025-2026, 7. And in 2026-2027, we had 4. And we'll get to the rationale behind why me putting these statistics across. Now, we have a serious problem of security compromises in South Africa. We have these security compromises because responsible parties don't have adequate measures to protect the personal information that they process, the personal information that they store. And if you look at this slide here, depicts the numbers, the growth in the numbers from 2021. We started off with only 202 security compromises. And then we moved from there to 2022, in the 2022-2023 financial year, to 492. And then in the 2024-2025 financial year, 2,374. And in the 2025-2026 financial year, 3,219. We are currently sitting at 797 security compromises, and we still have a long way to go before the end of the financial year. So you can see the growth in the numbers. Now, I felt that before we start dealing with issues relating to the real heart of the Act, we should actually focus on the challenges that we are having as a regulator, that we've picked up in the last few years. In the complaints, under the complaint investigation subdivision, there are a few challenges. One of them, the first one being that there are complaints outside of the jurisdiction of the regulator that we receive. So what it simply means is that people might not be fully understanding our mandate as the information regulator. There's also non-adherence to the timeframes by responsible parties. When we receive a complaint and we then issue a letter in terms of Section 79 to a responsible party, for the responsible party to comment on the complaint, usually there is no adherence to the timeframes. And then we then have complainants that seek remedies that we cannot, as a regulator, sanction, or that are not available to us as a regulator. Monetary, just to give you an example, monetary compensation from a responsible party. That is not something that is within the purview of our responsibility or our mandate. Now, one thing that we can all agree on is that there's a high rise in the number of direct marketing complaints. I'm sure today most of you are going to receive calls from direct marketers. So you have not given them your number, but somehow they will call you. So that's some of the challenges that we are having also. And then the use of automated calling machines and cold calling for purposes also of direct marketing is something that we are having. Within the compliance sector, non-compliance with POPIA by the public sector. And I'm specifically saying non-compliance by the public sector because what we've picked up is that the private sector has made a concerted effort to ensure that it invests substantially in compliance with POPIA. But within the public sector, and we had 2 weeks ago, we had a meeting with the Department of Transport. Today, I'm going to name and shame a bit. So we had a meeting with the Department of Transport, and what transpired in that meeting is that in the public sector and within some of the government departments, what happens is that somebody would look at, here's so and so that is sitting in records management. Maybe we can. That means that particular recruitment agency, thank you very much. Then it means that recruitment agency is an operator and has to adhere to the provisions of the Act. But when there's a security compromise, then what happens is that The responsible party will then say, but it is not our responsibility. We are not the one that has unlawfully processed the personal information. It is the operator that has unlawfully processed this the personal information. And we will look at some of those things. And then there's generally a lack of understanding of the provisions of POPIA. Now, under security compromises, we've already touched on some of the challenges, the high number of security compromises within the public sector, failure to report security compromises, no incident response plans, inadequate safeguards, non-adherence to regulator timeframes also. Now, we have begun, and I'm sure you picked up when in one of the highlights there, where we are talking about monitoring. We have proactively started a process to assist the responsible parties, assist them in the following manner. Under Section 40, subsection 1B, Roman figure 1, we are mandated to monitor compliance by private and public bodies with the provisions of our Act. And we then have decided that we are going to randomly choose organizations and assist these organizations. So what we do is that we choose about X number of organizations, and we say to this organization, we ask them a few questions. Tell us, do you have a compliance framework which is required under Regulation 4? Your policies and procedures. Do you have privacy policies? Do you have a retention policy? Do you have information security policy? Do you have incident response plan? Maybe just by a show of hands, if we're to sit here, are you aware of the fact that your organization has a compliance framework? Can anybody put their head on the block and say, well, I'm aware that the organization that I come from has a compliance framework? Okay, there are a few people. Okay. That's encouraging for us as a regulator. So what this slide just depicts is that in the 2025-2026 financial year, we had the number, it just depicts the numbers that we had identified, a number of public bodies versus the private bodies. The 2025-2026, which was 41, we had 20 public bodies and 21 private bodies. And in the 2026-2027 financial year, we had a total of 11 public bodies and 9 private bodies. But what I'm just also illustrating in this particular slide is that there are challenges that we have. Some of the responsible parties that we write to simply do not respond. Some of them simply say to us, after all this time, simply say to, well, we are not aware of the existence of POPIA. Now, this slide is a name and shame slide. South African Football Association of South Africa. The Bafana may be representing us well at the World Cup. But the fact of the matter is that we wrote to SAFA and we said to SAFA, where is your compliance framework? Show us exactly what I've been talking about in my previous slide. And SAFA said to us, well, but we are not aware of this act and we require time to still come up with the policies. So we have said, and we do this. Remember that there are two aspects of us doing this work. You have the monitoring part, which is done under Section 40, which is not punitive in nature. And then we have Section 89. So when we come to you under Section 89, when we come to assess you, you must know that you are going to possibly have an enforcement notice arising out of this. But from this particular exercise, what we do is that we then say to you, we note that you don't have a compliance framework, you have not conducted a PAIA, and we'll get into a PAIA just shortly. Go back and go and conduct these things that you have not conducted. And then come back to us after X number of days and show us, demonstrate to us that you have indeed done this work. Now, we also had South African Council for Architectural Profession. They requested, we wrote to them. And when we wrote to them, they then said to us, well, and the issues that we identified is that some of the organizations, when we interact with them, we can pick up that somebody said somewhere, and there was really a cut and paste of this. And we're saying cut and paste because you will see in their policies, somebody would refer to the GDPR. Now, we don't, security compromises, and in the privacy policy, they were saying that security compromises are reported with the GDPR. Now, clearly, it means that somebody sat and looked at a model somewhere and just did a cut and paste and did not properly customize it to the situation in South Africa. And that's what we then picked up, and we flagged some of these issues. And they then said, well, let's have a meeting. And we said, well, but we shouldn't be having a meeting about these things. Compliance does not require us to have meetings. It requires you to go back and comply and come back to us and demonstrate that you have complied. The National Department of Transport, there was no response to the monitoring, and they then came back to us after the time after the deadline, and they said to us, can you give us a little bit more time? We're still going to put together some of these policies. And the list, here's the list there. I'm not going to go through to save time, but you can see there are you have both private bodies there, and you have public bodies on that particular list. I hope that none of you are appearing on this list in this room. Or you are, or you are not appearing on this list. Right? Maybe we should just take two minutes and just float as a regulator. We are a fairly young regulator, but in the time that we've been in existence, we have been able to make significant inroads, which has also culminated in us issuing certain infringement notices. Our first direct marketing infringement notice was issued against FT REMS, and initially we had the fine that there was a 200,000 rand penalty that was imposed in relation to FT REMS. Blowback municipality, it was 500,000, which the court we went to court. The court then reduced it to 200,000. Department of Justice, I've just mentioned it, 5 million, and the IEC, Independent Electoral Commission, 200,000, Lancet Laboratories, 200,000, and we issued an enforcement notice also in relation to Central Johannesburg College and WhatsApp. We're still busy with WhatsApp, and the WhatsApp matter is quite significant for us. I'm not going to really go into details on it, but it's significant for us in a sense that the regulator through this particular matter ensure that it protects the ordinary citizens by ensuring that WhatsApp has enhanced privacy, which is similar on the same footing as those of the European countries, because the protection that was offered to the South African citizens was not on the same level or the same scale as that of the European countries. Now, let's then go into the roadmap. We are now going to go into the roadmap to try and equip you with complying with our act, which is POPIA. We'll start off with something that the CEO touched on, and I'm not going to spend a lot of time because the CEO really went into detail related to this. All organizations, responsible parties must ensure in terms of Section 55 that it registers an information officer. So we felt that let's just zoom in a little bit on the duties of the information officer. The information officer is just generally responsible for ensuring compliance with POPIA. I'm going to summarize it like that. And then under Section 56, organizations can designate and delegate a deputy information officer. The Act allows you to do that. Now, the question that we sometimes get, some of the questions that we usually get is that, for instance, the last one that I had to respond to, I remember, was from the South African Police Services. And because they have a lot of different police stations, they were asking, can they have as many as possible information officers? And we said that the Act allows you to do that. And CIO, you will remember the matter that I'm talking about. But let's get into Regulation 4 now of POPIA. Right. So Regulation 4 enjoys responsible parties with certain responsibilities. As a responsible party, you must develop and implement, monitor, and maintain a compliance framework. This framework should ensure that as organizations, you adhere to POPIA and the 8 conditions for the lawful processing of personal information, including you having a privacy policy, a retention policy, information security policy. Does anybody know, do we know what a retention policy is? Most of the organizations, when we go there, Mr. Mazibu forms part of the assessment team when we go and assess the responsible parties. And for some reason, organizations keep documents containing personal information indefinitely. There's even a room that is allocated for this thing. When you get into the room, there are just files that are stacked against the wall. And it's personal information dating back from years ago. And you ask, but why is this information here? And there's nobody that can give you a satisfactory answer relating to why the information would be there. So if you still have personal information and the law does not empower you to have that personal information, then you must know that you are contravening the provisions of POPIA. Then you've got to conduct a personal information impact assessment, what we call a PAIA, and we'll get into details around that. And you must develop internal measures and systems that would allow you to comply with the provisions of POPIA. And more importantly, you must conduct internal awareness sessions. This is what Regulation 4 prescribes. And most of the time, we go to organizations and we ask staff members, because as part of our assessment under Section 89, what we would do is that we would engage also with the staff members and we would ask the staff members, who is your information officer? And most of the time, they don't know who's their information officer. And we would ask them, when was the last time you received training? And they would say, when I first started working here. Okay, when did you start working here? 5 years ago. Yeah. So those are the sort of things that we are highlighting as a responsible party. POPIA, the training of POPIA must be an ongoing thing. Let's go to the slide that deals with the compliance framework. Although a compliance framework is not defined in POPIA and specifically under Regulation 4, it is a structured set of policies, procedures, controls, and standards that is aimed at ensuring that as an organization, you comply with POPIA. It does not prescribe a single mandatory framework, but requires responsible parties to take appropriate measures to ensure that it complies with the Act. Now, what is it as a regulator that we want to see you having in a compliance framework? You must have accountability. There must be an appointment of an information officer, and you must clearly define responsibilities to ensure compliance with POPIA. And under policies and procedures, you need to have a privacy policy, you need to have a retention and destruction policy, information security policy, and an incident response plan, and documented PIA, which is the personal information impact assessment. And you must also, under training and awareness, you must demonstrate that you have this continuous training of staff members. I was tempted CEO when sometimes the CEO, what the CEO regularly says is that sometimes when you have power, you must utilize it. So because CEO, as he's already mentioned, he said he will be going on retirement in the not so distant future. And he has taught me something. So I then decided CEO, as part of the work that we do, we usually go in and assess responsible parties. And I want Mr. Mazibu, because when we get to condition 7, there are certain things that I want him to highlight from a technical perspective. Can I just find out, are there people that are in the IT environment in this room? Are there people that are in the IT environment? Yes? No? All right. Yeah. We don't seem to be having anybody in the IT environment, but Mr. Mazibu will highlight a few things that I've asked him to highlight. So, what is this PIA, this Personal Information Impact Assessment? It's a documented assessment of the processing that identifies the risk and impact of such risk on data subject on the privacy of data subjects, apologies, and sets out recommendations for managing, minimizing, or eliminating the risk and its impact. POPIA also does not provide a detailed methodology for conducting PIA, but Regulation 4 requires that information officers should ensure that a PIA is conducted to ensure that adequate measures and standards exist to comply with the 8 conditions. So when is it that you should conduct a PIA? Before, as an organization, before you process or before you begin to process any personal information, where you have made changes to your processing activities. In other words, let's take a few examples. If you are going to have a new HR payroll system, remember that because personal information is involved in that, you will then need to conduct a PIA. Or when you introduce new technologies such as biometrics in your offices, you might introduce a system where staff members use their fingers to gain access to the building. So that then requires that you must conduct a PIA, an automated decision making, and the use of artificial intelligence tools. I felt that it was also important for us to just highlight the fact that we are going to be issuing a guidance note in the 2026-2027. In fact, we have already put together the first draft on conducting a PIA. Now, I want us to get into the 8 conditions for the lawful processing of personal information. But maybe before I do that, I must make it as practical as possible for your benefit, so that when we get to deal with these 8 conditions, it's clear. Maybe let's simplify it. Simple guide to, let me call it a simple guide to the 8 conditions. Accountability, because sometimes you look at the Act and the Act is a bit technical. So let me try and break it down for you, what they mean before we get into the 8 conditions. Under accountability means that as an organization, you must make sure that personal information is handled properly. That's all that it means. Simple example, Company X must have policies, it must have procedures and staff training in place to ensure compliance with POPIA. That's all that it means under accountability. And then processing limitation. Let's go to processing limitation. Processing limitation means that you must only, as a responsible party, collect and use personal information in a lawful and reasonable manner. Let's take an example. You go to a gym. If a gym needs your phone number to contact you about your membership, it cannot collect details that are unrelated. For instance, such as your medical history, unless there's a valid reason. So what is the key idea there? Collect only what is necessary. Now let's get to the third one, purpose specification. Purpose specification, what it simply means is that people must know why their information is being collected. Simple example, an online store tells customers that their addresses are collected solely to deliver whatever that they purchase online. So the key idea here is that be clear about the purpose from the start. And then there's further processing. What does further processing mean? It means that information collected for one purpose should not later be used for an unrelated purpose. Here's a simple example. A school collects parent contact details for emergency communication and should not sell this to advertisers, just to give you an example. So the key idea here is don't change the purpose without a valid justification or without consent of the data subject. And then the fifth condition is information quality. What does it mean? Simply mean personal information should be accurate, complete, and kept up to date. And whose responsibility is that? So if as the information regulator, the information regulator is responsible to ensure that my personal information, because I'm an employee of the information regulator, that the information that it keeps is accurate and is not misleading and is up to date. So it should have mechanisms in place to ensure that that personal information is correct and has been updated. Some of the organizations, some of the banks, when you phone the bank, the first thing that they will say is, we've got this number of yours and we've got these details. Are these details still correct and are they still relevant? So what is the key idea here? Key idea is that incorrect information can lead to unfair decisions being made on the basis of the incorrect information. Then we have another condition, openness. What does openness mean? It means that people should know what information is collected about them and how this particular personal information that is being held by a responsible party is going to be used. So an example here would be a business provides a privacy notice explaining that what it collects, the personal information it collects, why it collects it, and who to contact with questions. So what is the key idea here? The key idea is, as a responsible party, be transparent. And then we have security safeguards, and Mr. Mazibu is going to spend just a few minutes on security safeguards. But security safeguards essentially is condition number 7. We call Mr. Mazibu, by the way, condition number 7 because that is the area of expertise. So what it means is that personal information must be protected against, as a responsible party, you must ensure that you protect personal information against loss, theft, or unauthorized access. That's what it simply means. You must have those measures in place to ensure that you protect that personal information in that particular manner. Simple example. A company uses passwords, encryption, backups, and access controls to protect employee records. So the key idea here is that keep personal information secure. And then we have the last one, data subject participation, condition number 8. What does it mean? It means that people have rights over their personal information. So a simple example here is that an employee can ask to see his information from a company which holds the personal information about them and request corrections if the personal information is wrong. The key idea here is individuals should be able to access and correct their personal information. Now, let's quickly get into how we should comply. We want you to comply as a roadmap to complying as an institution. We can pass this. Let's go to condition number 1. Let's go to condition number 1, madam. So there are steps that we have put together on how to assist you to comply with POPIA and the 8 conditions. The steps to take under accountability. When you live here, make sure that if you don't have an information officer, make sure that you appoint an information officer and a deputy information officer in line with section 55 and section 56. Make sure that you take accountability. I've explained what condition number 1 says. Make sure that you take accountability for ensuring compliance with the provisions, all the provisions of POPIA. Make sure that you conduct a personal information impact assessment and conduct internal training or awareness. Develop, implement, monitor, and maintain a compliance framework and report security compromises in terms of section 22. Under condition number 2, it has 3 parts to it. It has the lawfulness part of it, it has minimality, and it has processing justification under it. So this is what you must do to ensure that you comply. You ensure that all the information that you process is lawful. And you must request only that information that is necessary and adequate for a particular purpose. And when you process a particular personal information, you must have a justification for processing the personal information. And those justification, I always say, I think for me, one of the most important sections for me is section 11. It has a whole lot of justifications. And if you want justification, one of them, which is the one that is mostly used, is consent, which is 11A. So the basis of most of the time, remember that Ms. Zondi, when she stood here, she said, we are going to be taking your photographs and we're going to be making videos. And if you don't consent, so we are processing your personal information as an information regulator, but we are relying on consent as a justification for us to be processing the personal information, which accords with the provisions of section 11, 1A. Under condition number 3, we have there's two aspects to it: collection for a specific purpose and the retention of records. I've already touched on some of these aspects. Ensure processing has a specific purpose, draft and implement a retention policy. So within the regulator, what we need to do is that we must have the retention policy and a destruction policy. In other words, beyond the period that is allowed for us to be processing the personal information or storing the personal information, we must have a destruction policy, and somebody has to monitor the destruction policy. You can't have a retention policy, and most of the organizations, when you go to them, some of the people whose records you have are long deceased. They passed away 15 years ago, and you are still keeping the personal information in question. So you must only keep records for a particular purpose, and but there are exceptions, obviously, for historical purposes and statistical purposes and research purposes. There's also that proviso that is given. Now, under condition number 4, further processing, the further processing must be compatible with the purpose that you collect information for. So steps that you need to take to ensure that you comply with the provisions of the Act. Do not reuse or pass information for a different purpose. Do not post personal information to personal WhatsApp groups. Inform data subject always of the use of their personal information. I've already gotten into details around this thing. Information quality is very simple. You must take reasonable steps to ensure that the information that is collected is complete, accurate, and not misleading. Maybe I should ask a question. Do you have mechanisms in place to ensure that the information that you collect is complete, accurate, and not misleading? In other words, if an employee within your employment or within your institution, if I'm a female and I get married, would I know that how would your HR ensure that that it updates my personal information? Are there mechanisms in place to ensure that personal information has been updated? And if you don't have those mechanisms in place, you may be skating on thin ice relating to compliance with the provisions of POPIA. Need to update information when necessary and raise awareness of the impact of incorrect data. Under condition number 6, documentation and notification to data subject. You need to develop and maintain a PAIA manual. You must develop an internal privacy policy, develop a privacy policy and a privacy notice or a privacy policy for employees also, develop a data subject privacy policy, add disclosure to contract, example, consent, objection, and withdrawal, add disclosures on website and apps, and add disclosures on telephone calls. Insofar as condition 7 is concerned, I felt that it was important for us to give condition number 7 a little bit of attention. And I've asked Mr. Bazibu very briefly. And the reason why I'm doing this, colleagues, is that we pick up quite a number of issues when we go out and conduct these assessments in terms of section 89 and some of the complaints that are coming through. And I felt that because he's in that particular space, he speaks the language, the IT language, I must ask him to come and actually talk to you very briefly about some of the things that we pick up. And then I will continue just to wrap up the presentation so that he equips you. When you leave here, you have a roadmap of some of the things that you must highlight. If your IT division is not here, so that he just you go back and you spread the message to your IT division. So, Mr. Mazibu, very briefly, if you can come through and just touch on condition number 7 and some of the issues that we pick up in our Section 89 assessments.
Thank you very much, Advocate Bikang, and good morning to everyone. So under condition 7, the main theme there is for us to protect the information that we have. So what we've noticed is that the moment we talk about this condition 7, like Advocate Bikang said when he started, is that the assumption is that we are talking about digital information only. But we are referring to both digital and the physical information that is being processed by organizations. So if we start at the theme that says you have to have both technical and organizational measures, I just want to give a difference between the two and just break down and how the two tie together. So if we look at the organizational measures, they're at the bottom, but those are what inform our technical measures, as you see on the top. Because here, as an organization, the first point in compliance would be to look at your information that you are processing. And once you have an idea of what it is that you are processing, you would then assess the risks. Where are we processing this information? Where is it based? Who's in possession of it within the organization? Who's allowed to view it? That talks to access control. And we would then have to develop like guardrails around how we would do this as an organization. So that's where we start to talk about the processes that we have as an organization, the people that implement these processes. I will touch on the challenges as I go along, because right there with people is where we start to see the first one. A lot of organizations, by virtue of having an IT department, assume that then the information security aspect of that is taken care of. But it is very important to have a clear distinction and separation of these duties. I understand that there are no people in the room, and maybe that is good as well, because they are not the ones who employ themselves. They are not the ones who put themselves in the room. And the people in this room are the ones who need to recognize that security is a business imperative. You need to have someone who keeps check the IT person, because they have their own objectives. They want to do things quickly. They want things to move fast, you know. But the IT security keeps an oversight over that to ensure that as you are moving as fast as you are you making sure that adequate security measures are implemented? Are you putting the access control measures in place to ensure that only the right people have sight of the information? That's where then we get to inform these technical measures that we put in place, like the encryption measures, the access control, the firewalls, and intrusion detection systems, you know, the data loss preventions. These are all informed by the risks we've identified. And so once we've got these measures in place, it's important to understand that this is not the be-all and end-all. We will still find that there will be security that happen. And that brings me to the next important point that organizations need to take care of. We saw in the graphic that was put up in the beginning that there was an exponential increase in the number of security compromises, from like 200 right up to the 14 times factor of that number. And that is not caused by necessarily, yes, there has been an increase in the attempts to compromise organizations, but it's also the reporting of these. There won't be statistics if organizations are not reporting what is happening. If you have a security compromise and you're not reporting it. If someone is meant to send an email containing personal information to one organization and inadvertently says it to someone else, and maybe they return it, that is a security compromise. That must be reported to the Information Regulator, because there were data subjects that were impacted by that. And sometimes, because it will seem by we will just let it go and not take heed of it. But that then puts you at odds with the Information Regulator, because as part of Section 22, you are obliged to report security compromises. And that brings us to the incident response plans that we need to develop, where it must be tailored to the organization. We see a lot of malicious compliance where organizations are going out getting policies created for them by, these companies that will say, I'll create the whole compliance journey for you. Meanwhile, they are going to ChatGPT and Gemini, generating documents for you, handing them over. They are generic. They don't talk to your organization. Now, a security compromise happens, you need to respond. You are unable to, because the playbook you have doesn't talk to anything that you have when implemented in the organization. So it's very important. And the operator agreements, which is the last point we saw there, where if you have people processing information for you, have agreements in place. Hold them to something on paper to say, you said you would have these measures that are like mine implemented so that you protect the information. Where are they? And in fact, from the get-go, when you bring these people on board, get them to do assessments on themselves, just like you will have to do assessments on yourselves. Get them to do these assessments to see where their vulnerabilities are, to see where they lack, so that they can rectify those, because that's what the Act requires as well, so that continuously we look at where we are deficient, we rectify that, and we are able to continue, so that anytime we have compromises, we're able to respond effectively. We can't do anything, colleagues, about zero-day attacks where the manufacturers themselves don't even know that something is coming. But we are able to respond to those if we have a playbook on how we respond to security compromises. I don't know, Advocate, if I've missed anything, but you'll just cover it. Thank you.
Thank you very much, Mr. Mazibu, for that. I'm elated to the fact that I have eaten into Mr. Dimba's time. Mr. Dimba, I apologize, Program Director. The last condition, colleagues, is condition number 8. And I've already touched on this. It's data subject participation, and it has 3 parts to it: access to personal information, correction of personal information, and manner of access. And essentially, the steps that you need to take is you need to allow for access to information. Data subject has the right to know if you hold personal information about them, and that you as a responsible party must confirm that it's free of charge. And you must develop a form or make use of a form that is substantially similar to one contained in the regulations. And the data subject may use the form to request deletion, correction of personal information that is inaccurate, that is irrelevant, excessive, out of and unlawfully. And maybe just the last 100, from section 100 to section 106, that tells us about what we can do as a regulator. There's a contravention, and as you would know, the highest fine that can be imposed, infringement notice, is 10 million or 10 years imprisonment, or both the fine or imprisonment. You will go and read that for yourselves, colleagues. I hope that what we have provided to you would have equipped you to have a better understanding of what this Act is all about. And I thank you, Program Director. I apologize for going overboard slightly, and thank you very much, Mr. Dimba, for allowing me to eat into your time.
Thank you so much, Mr. POPIA, and Chapter 7. I hear that's what they call you. We still good, colleagues? Feeling a bit, yeah. We are trying really to help you not be part of our statistics and make an example of you when we go to the next province. Thank you so much. Colleagues, I'm going to invite Mr. Dimba, who's then going to take us through the presentation on the promotion of access to information. Can you welcome him with a round of applause? Thank you. Sorry, Mr. Dimba. I have one hand. Yes, sir. Yes. Yes. It's fine. You can just indicate, sir, because we're still going to have a round of question and answers. I'm just allowing you. I don't want to censor you, but yes. Can we proceed? Yes. Yes. Oh no, we do. I'm sorry to interject, my good sir. Okay. Someone is holding a mic. Please, can you turn it off? We'll absolutely. Yes, but ngiyaxolisa, baba, I will have to cut you off because I will definitely have this session because we are timed and we will be sharing all the slides and information that you require. Even the guidance notes that we do have available, what advocate was referring to. We'll definitely start with you at the Q&A session. I'm just trying to control this meeting at this point, but we'll definitely come back to you, my good sir. I do apologize to do that. Please do allow me to invite Mr. Dimba. So we do proceed with the PAIA presentation so we get quickly to the question and answer session. Thank you.
That's what always happens when you speak after Advocate Buikanyo, because he is so good. People want to hear more, want to get more from his presentation. But you will be given copies of whatever that we are going to share with you today. Advocate Buikanyo used to be a chief prosecutor in Pretoria. And my difficulty in working with him is that whenever we walk the streets of Pretoria, there will always be somebody stopping him to say, "Hey, counsel, how are you? I haven't seen you in a long time." And half of them are people he sent to prison. That's my good colleague, Advocate Buikanyo. Good morning. Is it morning? Yes, it's still morning. Good morning, colleagues. Even those at the back, hello. Hello. You know, when you are from Cape Town, when somebody says hello, you know you're in trouble, actually. It's often not a sign of, it's not a positive greeting. I don't know, are there people from the Ngushwa municipality here? Ngushwa? No. Great Guy municipality? Are they here? Emahlati municipality, are they here? Please tell them I said hello. You will know why later. Colleagues, I'm going to give a short briefing on the work that we do on PAIA. Now, my work is going to be a very brief because you are all aware of PAIA. PAIA has been in the statute books for now 25 years and more. So really what I'm here to do is to give a refresher on some of the aspects that relate to the Promotion of Access to Information Act. Can we, we'll move to that slide where, just to summarize our mandate as the Information Regulator, we cover two rights: the right of access to information in terms of Section 32 of the Constitution, and we cover the right to privacy, but only insofar as it relates to the protection of personal information. That's in terms of Section 14 of our Constitution. Earlier, the CEO emphasized the importance of the Bill of Rights, Chapter 2 of the Constitution. So that basically is our mandate. We advance the protection and the promotion of these two rights through two legal instruments. Okay, I'm not sure how to deal with that, but I'll try and bring up my old shop steward voice. Maybe you'll be able to hear me. So we deal with these two pieces of legislation. So in terms of the right of access to information, we have the Promotion of Access to Information Act, which gives effect to that right. In terms of privacy, we have the Protection of Personal Information Act, which Advocate Buikanyo has spoken about. So really ours is to assist both the public and institutions in striking this balancing act between the two important values of transparency the rights of those two values, access and protection. Can we move to the next slide, please? We can move to the next one. We're going to try and move very quickly through this one. The next slide. So, as I said, it's a refresher on what you already know. So, in terms of the Promotion of Access to Information Act, this is a legislation that gives effect to people's right of access to information, which essentially means the public has a right to ask information that is held by public and private bodies. The only qualification exists insofar as the information that is being sought is being held by private bodies, that is to say businesses, NGOs, professionals involved in a trade or occupation. When you seek information from what is called private bodies, they have to show what rights they seek to exercise or protect by accessing that information. So basically, if you go to a bank, you seek information that is being held by a bank in terms of PAIA, you will have to tell the bank what right you seek to exercise or protect by accessing that information. But insofar as public bodies, that qualification does not exist. So officials from public institutions, you are not allowed to ask the requesters why they want the information that they are asking from you. There are reasons for asking for the record that you hold as a public body has no bearing on whether or not they should be given access to that information. Can we move to the next slide, please? So again, I said this is a refresher. So a requester will have to formally make a request for information as prescribed in the legislation. So the legislation provides that a request needs to be submitted in a form that is prescribed by the regulations. Now, this is where we come to the refresher part of this. A long time ago, there used to be Form A that was used to make a request for information. Now, we no longer have that Form A. We have Form 2, which is used by the requesters to make a request for access to information. And I am mentioning this, colleagues, specifically because this is a problem for us in my division. Quite a number of the complaints that we receive, we have to reject as the Information Regulator because the requests are made using the old repealed form, that is Form 2. Now, people get these forms from you, from the public institutions. In your manuals, a lot of you still have these old forms. And so please, we urge you, we appeal that you update your manuals, have the new forms attached to those manuals, and also make the new forms available to members of the public so that we don't have to send them back to say, go and file your request afresh because the form that you used is an old form. Of course, there is an issue around 30 days within which a request needs to be responded to. This is yet another challenge. Quite a number of requests are not being attended to within the 30-day period that is prescribed. This is often called a mute refusal or a deemed refusal. I've only been in this position for, I think, only 6 months now. But I can assure you that in the 6 months that I've been responsible for this division, almost 80 to 90% of the complaints are on the basis of deemed refusals. That is to say, the officials simply ignore the request or do not respond within the prescribed 30-day period. It's a big concern, colleagues. All right, I will not cover in detail the grounds for refusal of access, except just to say the right of access to information is not an unlimited right. It will be limited by other considerations. There will be circumstances wherein you will be allowed as an information officer or deputy information officer to deny access to information. Such refusal of access to information needs to be based on the grounds for refusal of access to information as provided for in Chapter 4 Part 4 of PAIA, where you are provided with the grounds upon which you can refuse access to information. For example, if the information relates to another person, a third party, or if it relates to national security issues, there are many grounds that are being provided for just to provide the legal limitation to the right of access to information. Please do not refuse requests for information on any other reason outside what is provided for in Chapter 4. So you will not be able to say a requester cannot get access to information because if we disclose this information, it's going to embarrass the municipal manager, or it's going to embarrass the HOD, or it's going to embarrass the managing director of this private company. Embarrassment is not a valid ground for refusal in terms of PAIA. So, and we always catch these out. So please try not to do this because we will indeed find on behalf of the requester when you deny access to information on grounds that are not provided for in the legislation. Can we move to the next slide, Ms. Kumar? So what do we do as the PAIA division? Our work can be divided into two main buckets of activities. The first one is complaints and investigations, wherein we receive complaints from members of the public based on the decision that would have been made by the Deputy Information Officer. So we get these complaints, we and monitoring. And I will not go into detail on this one because the CIO, Mr. Luyaba, is going to cover quite a lot of ground on what we are finding with regards to compliance. But I can just share with you what is it that we look for when we go and monitor or assess the extent to which you are complying with the Access to Information Act. Can we move quickly to the next slide? So when we do our assessments, we go out and we conduct these assessments. These are some of the things that we look for. In relation to public bodies, we want to test, number one, is there a manual, a PAIA manual in terms of Section 14, if it's a public institution, or Section 51, if it's a private body. The manual is a very important instrument because it gives more information to the requester on how your institution operates, who is responsible for that institution, who is responsible for receiving requests for information, what types of information are held by that institution. It's like a menu that they consult when they want to access information about your institution. We also look at whether the manual is available as prescribed. Is there a physical copy of the manual in your building? Is the manual available on the website? And then for information, we need to make that list available, put it online and submit it to the Information Regulator. For private bodies, they don't necessarily have to compile this list, but if they do, they are also required to put it up online on their websites. Section 32, reporting. You have to tell Parliament the extent to which you are implementing this legislation, and around how many requests have you received, how many did you deny, how many did you approve, has there been litigation on any of the decisions that you've made, etc. Unfortunately, this condition is often honored in breach and not in compliance. Again, Mr. Luyaba is going to share with you some of the stats around the submission of Section 32 reports, or Section, I think it's Section 80, subsection 3 reports if it's a private body. We are currently in the middle, well, towards the end now of the reporting period. We need, I think there are about, what, 280 something municipalities in the country, 800 public bodies, and almost 3 million private bodies, depending on which database you are using. Now, I don't want to embarrass people, but I feel like I want to ask if all of you have submitted your Section 32 reports or Section 84.3. You still have time to do so until Monday. You have until Monday to submit your report. Of course, the deadline is the 30th, but anything can happen between now and Tuesday. So rather aim for Monday for your submission. Mr. Yaba will show you that a lot of you are not doing well in this. And I say this is important because this is not for us as the Information Regulator. This is for National Assembly. These reports go to the National Assembly. And by and large, municipalities at most are not complying with this requirement. So those are the main things we look for in terms of compliance. Can we move to the next slide? Now let's come to some of the compliance assessments that we've done over the years. I won't go through the entire slide, but I just want to indicate that in 2025-2026, we conducted assessments of district municipalities, NPOs, Schedule 3A entities. But a year before then, we looked at provincial legislatures and others. In 2023-24, we looked at provincial departments. And I think it's on the basis of the assessments that we did in 2023 that the Eastern Cape province is doing so well, because when we did those assessments in 2023-24, we found a lot of challenges in terms of compliance. And we shared that information with the provincial leadership through the office of Mr. Fortune and others. And the results are showing, because all provincial departments in the Eastern Cape are fully compliant now following the assessments that we did. But the municipalities are still struggling, which then brings me to the remark I made about Ngushwa, about Great Kai, and about, what was the third one? Ematlat. We have targeted those three specifically this year. It's a good thing they are not here, so we will catch them by surprise. So please don't tell them. But there's another category, there's a fourth category, which is a surprise. So it could be any of you, I won't say who. It's just those three that I'm privileging, but it's a good thing they are not here. As you can see, it's right there on the slide. Can we move to the next one, please? I will skip these slides because Mr. Yaba will talk about them. You can skip that. You can skip that one as well. I think that brings us to the end of our presentation, if I'm not mistaken, Ms. Kumala. Complaints and investigations. Just quickly, I'll go through. This is the final slide. I will go through the numbers in terms of complaints. So this only covers up until the the end of the last financial year. So these figures are only for the last financial year. We received a total of 664 complaints. Of those, 60 were regarded to be simple complaints, which means those are the ones we are able to resolve within 3 months or so. We had 164 complex complaints. Those ones take much longer to resolve, which leaves us with the bulk of about 213 complaints that we are investigating at the moment. I am worried about the figure for the rejected complaints. Now, this is when, as I said, people make requests using old forms, and we would like to ask you to assist us with this by providing correct forms. But sometimes it's not just about a form. Sometimes it's because a request is being made to a private body and the requester has not really shown what right they seek to exercise or protect by accessing the information. And therefore, we have no option but to reject those complaints. Next one, please. We can skip this one. It has been summarized already. I think some of the challenges, I've spoken about some of the challenges. The manuals remain outdated, old forms are being used, the lack of responding within the prescribed timeframes. Can we then move to the next slide? There's one major challenge I want to address with you, colleagues. That is the second bullet. Non-compliance with Section 23 of PAIA. Section 23 provides that if a request has been made for a record that the institution cannot find or cannot locate, the section requires that the information officer must depose to an affidavit which explains all the measures that they took to locate that record. We find that there is heavy reliance on this provision, but it's not being done properly. In a lot of instances, institutions simply say they don't have the record, and they put together a Section 23 affidavit. But when we analyze that affidavit, we always find deficiencies. Let me just give you one good example. A lot of you come from municipalities where people make applications for building or making alterations to buildings. So those things go to the municipality. Right? And then people would say, can I, maybe it's a neighbor that says, can I have access to the application that was made for a building application? And municipalities would say, we don't have this information. But you approved the construction of a structure. On what basis was that approval given if you cannot find the application that was made by the person that is building? So it's just one example that shows there's a problem with the Section 23 of PAIA. Can we move? Of course, this is also because records management practices are quite poor, especially at municipal levels. I think this was the last slide that I wanted to talk about. I don't know if there are colleagues from clinics here in the room. Provincial hospitals, regional hospitals, clinics. Anyone? Health facilities? They are hiding. I know they are here. People are struggling to access their medical records and their medical files, especially those that want to make claims to the Road Accident Fund. They come to the hospital and they said, I had an accident, I came to this hospital for treatment, and I want my medical file. And a lot of people are not getting those medical files. So there is an issue there in terms of accessing medical files that we need to work through. Maybe the colleagues from the Office of the Premier can maybe share.
That promotes transparency and accountability and informed decision-making. And by us not being compliant with PAIA, stifles the ability for members of the public to exercise and protect other rights. So I hope this was very helpful. And can we please give Mr. Timba another round of applause? Thank you so much. Okay, colleagues, we're now moving to the last presentation by our CIO, Mr. Luyaba. Please do excuse us. He's not going to be able to come to the podium. However, he is going to present from where he's seated because he wants to do a live demonstration. Now, we want to showcase to you, colleagues, that we have made it so easy for you to be able to comply with these two pieces of legislation. And thus, we have an e-services portal that we have created and which CIO will take us through some of.
Good morning, ladies and gentlemen. Am I audible? Maybe let me try and speak a bit louder. Am I audible now? All right. Please do excuse me. I'll be presenting from my laptop and the cable is not long enough to reach the podium. So I'll be sitting, but I'll go to the podium later on when we have to answer questions, unless I have to show you something from the laptop. All right, so my session is going to be a bit or slightly different from the format that my colleagues used. Mine will be a bit more practical. You've heard a lot about the legal requirements, the rights of the data subjects and obligations placed on organizations, both under POPIA and PAIA. And I'm going to be showing you a bit more practically how these come alive on the e-services portal of the Information Regulator. I'll take you through some of the services that we have available on the portal, how you can, how they help you to meet your requirements and your obligations as a public or private body. Before we get there, I want to start with a bit of violence this morning. I'm going to do some naming and shaming. Just a gentle reminder, colleagues. Compliance is not optional, and the Eastern Cape is not compliant at this point, especially local government. So can I see by show of hands how many people come from provincial government? Okay, see only 3 hands. And local government? Everyone in the room. Do we have any private sector in the room? Just one table over there. All right. Just wanted to see that before I start. So allow me to pick on local government for a bit. But before I do that, let's look into the colleagues from provincial government. Just a little disclaimer, all this information that I'm about to show you is publicly available from the portal. So anyone that logs in on the e-services portal will be able to see what I'm about to show you. So if you can't see it properly on the screen, you can visit the portal later and have a look for yourself. The portal is accessible from our website, inforegulator.org.za, and you can access it directly by going to eservices.inforegulator.org.za. All right, so to access this functionality that I'm talking about now, you go to services. Of course, you log in first. I've already logged in. You go to services. And then you go to the compliance status checks option at the top right of the screen. I see the screen is not very clear. So under that option, we've got public organizations and we've got political parties as well. I'll go into public organizations and I'll start with the provincial government. So if I select that option, and select the Eastern Cape. So as you can see from the at the top of the screen, we've got 13 provincial government departments in the province, and all 13 of them have registered with the regulator and submitted their PAIA annual reports for this current reporting period. I think that deserves a round of applause, ladies and gentlemen. I think this is exactly the kind of picture that we want to see across the country. Unfortunately, the picture looks very different when we move to local government. So I'll just scroll up and select a different category, local government, and then select the Eastern Cape province. Okay, as you can see from the screen, we have a total of 38 local government organizations in the province. Out of that 38, only 16 are registered. And only 11 have submitted their annual reports. 11 only out of 38. That's 29%. I think it was 10 yesterday. One submitted, I think it was Umzimvu after we visited them. Yeah, we need to get this done before the 30th. We've got literally 4 days left. I'm mentioning the 30th, it's been mentioned by Mr. Timber because that's a closing date for our reporting period for this current financial year. So when you get back to your offices later on today, and those that are going back on Monday, make sure that it's done. There's no more next week. This has been open for a few months now. We always open it from the 1st of April, and we send out reminders on a regular basis. But if you're not registered, you will never receive those reminders because we do not have your details. So make sure that it is done by Monday. So for you to be able to do anything on our portal, you need to be registered first. So for you to submit your annual report, for you to do any of the other services that we've got on there, you need to be registered. Now, let me just scroll down a little bit and have a look at who's actually complying and who's not. As you can see, a lot of the municipalities listed there have a status that is red. So let me start by maybe picking on the 2 metros in the province. And I saw a lady from Buffalo City when I was signing in. Buffalo City is not compliant. So if I just type metro there, and I can see the 2 metro municipalities there, and both are registered, which is good, but they have not submitted their annual reports. 4 days. And let's have a look at maybe the district municipalities as well, and I think that's even worse. We've got about 6 district municipalities, and only 1 is compliant at this point. The rest are not registered, and they haven't submitted. Do we have any colleagues from the district municipalities here? Okay, yeah, I see a few hands. Anyone from Jotka, be the one that's registered? Okay, so colleagues, please make sure that it's done when you get back to your offices today or Monday. All right, so I'm going to show you how simple it is to get this registration and other services that we've got on offer done on the portal. Of course, you need to be registered and log in. Registered as a user, first of all, and then you register your organization and your information officer. All right, so again, you've logged in, you land, after you've logged in, you land on the dashboard. And from the dashboard, you get a few options, but to get a view of everything, and we've got some stats on the dashboard that you can go through about the different services that we've got on offer. But to get the full complement of the services that we offer, you navigate to services. And that's where you'll see everything that we've got on there. And I'll start with the registration of information officers, which is where I said everything starts. And that option is available right at the top under registration and directories. So we've got information officers there. You click on that option and you get a few more options under that. There's new registration, there's my organization. That's where you see a list of all of the entities where you're an officer. You could be an information officer, deputy information officer, or even an admin officer. And automatically those entities will appear under your profile in that My Organizations tab. Download certificate option, that's where you are able to log in and download your organization certificate. And yeah, you can do this at any point. So we do send it out after registration, but let's say you lost it or you want to get an updated one after you've updated the details, you're able to then download using that option. And speaking of updating your details, under the My Organizations tab that I just spoke about, if there's been any changes in your organization, an IO has left and you need to appoint a new one, address of the organization has changed, you go to that option and you update the details there, and always make sure that the details are kept up to date. So if an information officer is leaving, before they leave, make sure that the new one is appointed on the system. Even if a person is acting for a short period, they must be added onto the platform. You can't at any point not have an information officer appointed on the system. You can do name changes of your organizations on there, but this is mostly for the private sector, where we connect directly to the CIPC and pull the details. For the public sector, you need to let us know, and we then do that on your behalf. You can deregister if an organization no longer exists, and we've got a step-by-step guide on there that guides you through the process of registration if you need assistance. So let me just quickly show you the start of the process for new registration. So you click on the new registration option, and as you can see at the top, there are 4 steps, but it's literally just 3. The 4th one is just a declaration that you need to sign. So in your case as local government, you will select the public organization option on there. And then we ask the type of public organization that you come from. And in this case, it would be local government. And let's say we're registering a district municipality, and then you select the name of your municipality from the list that's provided. Okay, so let's do Chris Sunny. Continue. If your municipality is already registered, we will tell you that it's already registered, and we won't allow you to proceed further because we do not accept duplicate registrations. All right, so you'll just capture the information that's required, the email address of the organization, the phone number, and the address. And I won't capture anything now, but the next step then is the information officer of the organization. You capture their details. Next, the deputy information officer or officers. You can appoint a number of deputy information officers. There's no limit. And under that page as well, I think you can add admin officers, so people that will assist with the capturing of things on the portal. It's not necessary to appoint deputy information officers. And I think it's mandatory for public organizations to have at least 1 deputy information officer. The last step is just a declaration where you confirm that you've given us the correct information. And after that, you click on submit, and instantly your registration is done and you get your registration certificate. So it's as simple as that. It takes literally about 5 minutes. So I don't see why you shouldn't get it done today, colleagues. So please make sure. So once you're registered, you then need to do your annual PAIA annual report. So you go back to services, and the second row that we've got on there is reporting and manuals, and the first option there is PAIA annual reporting. So to submit, you click on that option. We do provide some information, and we've got different options under the new submission. You can download a certificate for your submissions. We have recently introduced the certificates. We used to just send an email, but now we've got certificates for these submissions, and you can download these at any point, and they show the entire history of your submission. So if you've never submitted, it'll show for the previous years that you did not submit, and it'll show the latest year being submitted. You can view some stats on the submissions, and we've got an option again to that public organization compliance that I showed when I started, and we also have a step-by-step guide that can help you with the submission period. So let's quickly just start a new submission. You will get a list of organizations where you are an officer. Again, I mentioned any of the officer types, so information officer, deputy information officer, or admin officer. And if you're not added as one of those, then you cannot submit on behalf of that organization. So you select one of them. It will show whether they have submitted or not. And in this case, all 3 that are under my profile have submitted. And maybe just to show you what the form looks like after that. It's a very short form. Let me just go to the step-by-step guide. Let's just wait for it to load. Okay, so once you've landed, after you've selected your organization, you get asked a series of questions, and they're different for public and private bodies. For private bodies, it's 9 questions, but for public bodies, it is 12. So we ask you basic questions, the number of requests that you received for the reporting period. So it's normally the previous financial year. So right now, you're doing a report for the 2025-26 financial year, which is from the 1st of April 2025 to the 31st of March 2026. So number of requests received, number that was granted in full, and just follow the questions and then answer. And we only take numeric responses on all of those. And if you did not receive any requests in the reporting period, it doesn't mean you don't need to submit your annual report. You still need to log in and do that submission. And if you didn't receive anything, then you just type zeros in the response boxes that are on there. And at the end, again, you get a certificate that proves that you've submitted, and that's the end of the process until the following reporting period in the following year. So we do have other services like your security compromise reporting. If you experience as an organization any security compromise or data breach, that must be reported to the information regulator. Please do not hide it, because we will at some point find out and you might get into even more trouble for not reporting. So make sure that all the security compromises are reported. Again, we've got that functionality available on the portal. So if you go on the complaints and compromises section, we've got security compromises on there. You click on that option and you submit a new report. You fill in the form that's provided. But before that, with all of these services, you need to select the organization that you're submitting for. And once you've selected, then you'll be able to fill in the form telling us when the incident happened, some measures that have been put in place. Just follow the form. And I think, I'm not sure if we've put it on there yet, a step-by-step guide. But if it's not there, we're always there to assist when you need help. Let's move on to other services. We've got quite a number of services that we've built and made available. You can submit complaints on any public body for both POPIA and PAIA. So POPIA complaints are on there. That includes direct marketing complaints as well. So those spam calls that you get, you can log complaints against those organizations on the portal. So if you go to POPIA, POPIA complaints, you can start a new general complaint, you can start a new direct marketing complaint, and you just give us all the details, and then it goes to Advocate Buika and his team, and they start working on those complaints and responding to you. That goes for PAIA as well. It's a similar process, just different forms that you need to fill in. We've got services like we've got self-assessments under both POPIA and PAIA that you can take, just to guide you on what you need to do under both POPIA and PAIA. And yeah, it's not a formal assessment, it's just a guide to help you. We even have a personal one that guides your day-to-day use of personal information and privacy. It comes with a short course that guides you on any of the topics that are covered in the assessment. We call that the personal privacy score over there. You can upload your organization's PAIA manuals on the portal. You can upload your automatically available records. Mr. Timber mentioned that your PAIA manual must be available at your premises. So maybe by your reception, it must be available on your website as well. Now we've got a third option where you upload it on the portal, so that if anyone searches for your organization on the portal, they're able to download your PAIA manual from there. That's one of the things that I want to quickly show you, the organization search. So anyone can search for any of the organizations that are registered with the regulator by going to the organization search option. Not sure if you saw it, but under services again, the very first option says organization search. If you click on that, you get a text box where you can type in any organization name there. So I'll just search for one. So let me say InfoReg, and it found the Information Regulator, and you can then view details on that organization. We'll give you details about the actual organization first, so the registration number, when it was registered, the type of entity it is, the physical and postal address, all on there. We'll tell you who the information officer is. Our CEO is listed there as the information officer. Under deputy, we've got Mr. Jansen there, who's our deputy information officer. If the organization has uploaded the, also not PAIA manual first, but the annual reporting. So this is public, and anyone that logs in onto our portal is able to see whether you're submitting your annual reports or not. So we'll show you, in our case as the regulator, we submitted from the onset, so from the 23-24 financial year. When we made the portal available, we've been submitting, and we've got timestamps there for the submissions. And it'll show you the latest reporting that we submitted. So we said we received 10 requests. So answering that questionnaire that I showed you, we received 10 requests and 8 were granted in full. So it just follows whatever was done on the submission. We've got the PAIA manual. I said you can upload it. I think for public entities, it must be in at least 2 languages, if I'm not mistaken. We've got it in 3. We've got English, Afrikaans, and Sesotho. So you can download any of those from the portal. Same as automatically available records. If an organization has uploaded them on the portal, you're able to then download and see what they've got on offer. So this organization search can be quite useful as well when you need some information on different entities. Lastly, before I end, colleagues, if you experience any issues with the portal or you want to ask about something related to both POPIA and PAIA or any information regulator related matter, you can log a query on the portal. We've got a structured query management system that we call iSupport. So you can log a query and we make sure that it's tracked, it's directed to the right division for resolution. So use that iSupport functionality, top left corner, or it's available under services. And you can then log a new query and we're able to then provide updates on the query as any changes happen. And at the end, when it's closed, you will get a resolution that it's been closed with an explanation of what has happened. I think I'll end it there, Ms. Sondi. Thank you so much.
Thank you so much. So may we please give him a round of applause. And I promise you, colleagues, this is not how it looks on our actual website. I know we could barely see anything on the screen, but if you do go there, it's very easy to use. It's very visible. It's just the here, and we do apologize once more for that. But thank you so much, CIO. Can please give him another round of applause. All right, so we've come to the session where we'll have some Q&A. Please do not shoot me. It's time that is against me, and I am an advocate for open dialogue and communication in such sessions, but I will be trying to manage the number. However, I am giving you access to the executives, the CEO, when we do go downstairs just to have a little meal that you can still further interact with them when we are downstairs at the restaurant. But now I'll call for some questions. I will note them and then we'll have a response session before we then close today's session. So I see one hand here, the second there at the back, and then the third one here. Going once, twice, and another hand there, that's the fourth hand, and then we have a last hand there, the gentleman in the back. So we have 5 questions. We will note all of them. Okay, and I'll give you Sissy just because I like you. That's the last hand to Sissy there. 6 hands, and then we'll respond, colleagues, to the questions. Thank you. Please indicate your name and the institution, and we will then note all the questions. Thank you.
Thank you. Good morning to the chairperson and to the. Can you hear me clearly? All right. Thank you very much. Thank you to all the presenters. The presentations were very good. I think they were enlightening, and some of us have seen it before already, but I think it's important for the refresher courses. Just very quickly, I have about 15 questions that I want to pose. No, I'm only 5, but 5. Just Advocate Boikanyo, on the issue of the fines, are these fines being enforced? Is the Information Regulator enforcing it? Because I know that you spoke about Department of Justice, you spoke about some other institutions where there are fines being leveled against those institutions for non-compliance. But I'm asking, are you enforcing it? And then just as a secondary question then, where does this money go to? Does it go to the Information Regulator or to the public purse, back to the provincial revenue or the National Revenue Fund? Those aspects. And the second one that I want to ask, in terms of the presentation that you had, as well as Mr. Lujaba, the digital and physical information security. I know there was an incident in the province where we had Department of Human Settlements where their systems were hacked. It was last year, and we had to have several interventions made. The question I want to ask is that most departments, national and provincially, are covered by CETA, because those are sometimes compulsory services that we have to source from CETA in terms of the CETA Act. Have you engaged with CETA regarding their, I think, their level of security that they need to have in the various departments, national and provincial, to ensure that we are compliant then, of course, with the POPIA Act? Third one, broader capacitation. Today is one of those sessions, but I mean, we are about maybe 40, 50 in this room. I'm asking, what is the Information Regulator doing about ensuring broader capacitation for, especially at your local government level, where we find that there's, I think, serious issues of non-compliance. And I think that is where we need to target our capacitation. I'm asking, what is Information Regulator doing about it? Are they engaging with the National Department of COGTA and provincial departments of COGTA? Lastly, I know we have time constraints. During the session we had recently now in the week with the Office of the Premier and the very provincial government, the MEC for COGTA invited the Information Regulator to the next MUNIMAC to then engage with mayors and municipal managers on the issue of non-compliance by municipalities. So I'm just saying that there's a reminder that there is a platform for the Information Regulator, especially in light of the stats which really paint a bleak picture in respect of compliance at a local government level. Thank you.
We didn't get your name, you said from the, and which institution, my good sir?
My name is Rupert Fortune. I'm in the Office of the Premier.
Thank you.
Thank you.
That's the beauty of being fortunate as well and being Mr. Fortune, because you could ask 5 questions, but I'll ask the next colleagues if they can please keep it to just a minimum of at least 1. 2, I'll forgive you. Sunny?
Good morning, Program Director. My name is Sitembele Zenzile from the Leader Practice Council, also the Deputy Information Officer for the Leader Practice Council. I will apologize beforehand with the last 2 speakers I couldn't hear. I think due to the position that I'm sitting in, I also couldn't see the presentation, the slides that were being presented. I just have a few questions. The first one being about the information that is already in the public domain, and someone is requesting that information. What is expected of the information officer processing such a request? Because if you just refer them to where the information is in the public domain, would not that be considered as refusing to furnish that information? And should you provide that information without obtaining the consent of the data subject, would it not be considered as contravening the provisions of the Protection of Personal Information Act? And also with regards to a request of information from a person who sent you that information and you know that they already have it, would it be good grounds for you to say that you already have this information, you send me an email, it's a matter of simply retrieving that sent email? Would that be good grounds for refusing to furnish that information? And would it be fair to that data subject, or sorry, that requester, to charge them to give them the information that you already know that they have? My third question would be on the independence of information officers and deputy information officers. What is their level of independence? Are their obligations subjected to what the management of the institution or the company is saying? For example, I'll just make an example. When there's a data breach within the institution and the executive believes that it should not be reported, but you know, as your obligation as a deputy information officer, it has to be reported. And should it be the case that the deputy information officers are independent, what level of protection would be afforded to them? Should they go against what the executive of their institution is saying? And my last point, coming from a regulatory body myself, I'm usually on the receiving end of this point. How do you contact the information regulator? Because the numbers that are provided on your pamphlet, and they are also on your website, 010-023-5246, and that toll-free number, they are not working. The email address, the email correspondence are not being responded to. I'm sitting here with having sent communication to the information regulator on the 2nd of January 2024, and I've been making continuous follow-ups. To date, I haven't received a single response from the information regulator. So if you could please just advise me, am I expected to work in at Woodmead to be able to get assistance from the Information Regulator. Thank you so much.
Well, I was about to cut you off at 2, but I'm glad I actually allowed you to go to the 4th one. But we'll be responding. The third person.
Good morning, Chair, and everyone in the meeting. My name is Lonwabo Sophela. I'm responsible for legal services in the Eastern Cape Provincial Legislature. I just have one question, and unfortunately, my colleague who is responsible for risk management is also then part of the meeting, albeit she is still new with us. There's a position in some institutions which is a position of Chief Information Officer. And the position is obviously, and in most instances, a position for someone that is in the ICT environment for purposes of enhanced ICT governance. So you would have a CIO, but the CIO would not necessarily be a deputy information officer or one of the designated information officers. But when you note your ICT governance and your systems, they are currently going more towards being ICT based, as opposed to having now your hard records at process and your hard records at sub-pain management records that would give rise to requests. So the question or guidance that I would want us to get, so that when we go back in the institution, we are able to motivate for a CIO to be added as a deputy information officer. Isn't it ideal that it happens in that particular way, because you are more now going digital in terms of the information that would be subject to your PAIA request, and that would be susceptible to protection in terms of your POPIA. Thank you so much.
Thank you. You can go ahead, colleague.
All right, thank you. My name is Marshall. I'm from a private body, Dignity Group. I don't know if you can hear me. This is...
You can just lower it down a bit, but we can definitely hear you. Thank you so much.
Okay, my question is more of a practical. I want the team from the Information Regulator to assist us as an insurance company. We work with clients a lot. We receive their information in the process, and of course, clients come and they request, for example, policy schedules, policy contracts on a day-to-day basis. We get calls, we get those requests. There are other requests that I can also maybe identify from other departments, but these are more of routine requests that we get. Maybe also there's an example that was given, you walk into the Department of Home Affairs and you request for a death certificate. That happens, basically it happens every day. So in terms of PAIA reporting, after the reporting, after the cycle, I want an understanding on, are these the types of requests that we are expected to submit after the prior period, or there are certain types of requests that we need to be looking out for? Do we have to give a client a PAIA request, a PAIA form all the time to complete when they come and ask for a policy contract that we are holding, or there's a useful tip that you can give us on what we can put in a report. Thank you.
Thank you. Is that our last question? Yes? Sis? Or is it? Oh, yes. The gentleman, and then you can go ahead, sis, and then we'll end with the gentleman then. Would you like to try to project your voice whilst they sort out the mics?
Is it on? Okay. My name is Grace. I'm also from Dignity Group. I just have a question in terms of the PAIA. Is it the reporting? You mentioned the manual, and you said the manual needs to be physical and also on the website. I just wondered, is it either, or does it have to apply to all? That if you work, maybe if we have 2 or 3 branches, should the branch be holding a manual, or should it be in the office, or is it the one that is on our website? Thank you.
Morning, sorry, my voice. My question is on issue of
name and institution, my good sir.
OR Tambo District Municipality. I'm Akon Nkalweni. On the issue of the compliance framework, I see there's a part talking about the privacy policy. If you don't have that, because I don't remember that we do have it in our, just that we know that we must comply in terms of enforcing privacy and entrenching privacy. We don't have to that extent to say we have a policy on privacy policy. Now, if we don't have that in your assessment, does that mean you are fined or penalized for that? That's question 1. If you do have a policy of some sort or template, please share it with us so that we use, because I'm trying to think what do you actually put there. Okay, the other one is an issue of, I think it's PAIA now. The gentleman said they've got 90% of complaints in terms of deemed refusal. Now there's the second step after the 30 days. You appeal. So when the person, the person can just go and lodge a complaint without appealing, or they can, those things should first appeal, because I think when one requested an information, there's that second step to appeal, then the 60 days expires. A follow-up question to that, if the 60 days expired, and then you still have to start afresh to make a request, or because they would say, if, or you can put it even if it's outside the 60 days for an appeal time frame. If as a public officer, can I use this as a defense to say your 60 days have expired? Refer to the Information Regulator. How does this thing work? What are the implications of missing the 60-day period? Thanks.
Thank you very much, colleagues. I'm going to start with Mr. Dimba to respond to the colleagues that asked PAIA-related questions. Then we'll go to the Mr. Advocate Boikanyo, and then the CEO, and we will then, I think CIO, there was a question. Yes. Okay, and then the CIO. Thank you.
I'm going to try and stand a bit closer. Hopefully it makes a difference. I will start. It was a question to Advocate Boikanyo on the issue of enforcement notices, but I want to hijack the question from a PAIA perspective. So we effectively monitor the implementation of the enforcement notices. Once it has been issued, we track to see whether the institution has implemented the actions that were directed in terms of the enforcement notice. With Advocate Boikanyo, there are fines that are payable once a contravention has been established. In PAIA, we don't have fines, but we have criminal action available to us as the regulator. So we currently have 3 information officers that have failed to comply with our enforcement notices. One of them is the DG for State Security Agency. We've had to open a criminal case against the DG of SSA for failure to comply with the enforcement notice. So if we can take that kind of action against SSA, who are you to ignore us? Please don't ignore the enforcement notices. We track them, we monitor them, and we take them seriously. Remember, the enforcement notice has the same effect in law as a court order. So try not to ignore them, please. Mr. Zinzile from the LPC. This is a requester who requests information that was submitted by themselves to the LPC. I will direct you to section 63, subsection 2, B and C, which says a requester cannot be refused access to information about themselves or information that they themselves supplied to the private body. I think I'll use the private body because you are from the LPC, but have a closer look at section 63, subsection 2B and C. I think it will address your question. Let me just quickly see. Again, information that is in the public domain cannot be refused. So if it's in the public domain, you can't refuse that request. It's the same section, section 63. Let me just quickly see. Do you always have, oh yes, that was from the Dignity Group. Do we always have to ask people to submit PAIA requests? That's a good question. No. Remember that PAIA serves a particular purpose, and that purpose is to say, in instances where people cannot access information through normal means, then they rely on PAIA as the final resort. So if your existing systems are working to make information available, then continue to use those processes and those procedures. We say these are big R and small r requests. So big R is a formal PAIA request where a person says, I've been struggling to get this information. These people are refusing to give me this information. Therefore, I'm now using PAIA. But if it's just normal course of business, it's a small r. It's your routine requests. You know, I want my policy number. I want to know who's responsible for this task or this action. You know, those are routine requests. You don't have to force people to submit PAIA requests on those. The next question was on the availability of the manual. It must be both. The manual must be available both physically and online on your website. Now, physically, what does that mean? Does it mean that you must have a copy of the manual in every branch where you have your business operating? Now, the legislation simply says in your primary place of business. So I don't know what that means. A lot of people will say, well, primary place of business means our head office. That would be fine, but what if your primary place of business is a different place to your head office? I think only you can address that when taking into consideration the circumstances of your business. And I will give a section later. I forgot to note down the section, but you must have the manual physically in your primary place of business. And then the deemed appeals on deemed or the deemed refusals. That's a very good question. I'm not sure where it came from. Yes. So what normally happens is that if there is a deemed refusal, more often than not, 100% of the time, there will always be a deemed rejection of the appeal. Because remember, it's the same person that is responsible for this process, because the legislation says your appeal goes to the information officer, who then hands it over to the appeals authority. So now, if the information officer did not attend to your original request, it's most likely that they are not going to attend to your appeal as well. So what often happens is that somebody submits a request for information, they wait 30 days, they don't get any response within that 30-day period. Then they will have 60 days within which to submit an appeal. Most people do that. They submit their appeal within the 60 days after the end of the 30-day period, which means everything flows accordingly. But we do have instances where people do not submit their appeal within the 60-day period, and we often reject those complaints unless the person has submitted an application for condonation. Where they can give us reasons why they did not submit their appeal in time. What they normally say is, I didn't know when was the right moment for me to come to the regulator. And we always say, no, but there is a 30-day period within which the institution must respond to your request. At the end of the 30-day period, start to count your 60 days within which you need to submit the appeal. If you don't get a response within that 60 days, then you come to us as the information regulator with your complaint. I hope it makes sense. Yeah. Those are all the ones I wanted to respond to.
Thank you very much, Mr. Jimba. Mr. Fortune, your questions, the short answer is that yes, we enforce these fines. We have mechanisms that are provided for in terms of our act, specifically Section 109, that enjoin us or that empower us with the power of ensuring that where you don't pay, if there's an infringement notice and you don't pay, we approach the court in terms of Section 109, and we then get judgment against you. It's akin to a civil judgment. So the money is paid. We have quite a number of responsible parties that have paid, and the money is paid in terms of Section 109, subsection 9, to the National Revenue Fund. So it does not come to us. The other question was in relation to CETA, us engaging with CETA. The unfortunate thing is the following, that within the scheme of POPIA, there is a responsible party and there's an operator. Now, if you have somebody that does work for you, that processes the personal information, that person is dealt with in terms of the act and is deemed to be an operator. Now, what will then happen is that you then have to look at the provisions of Section 21, which then enjoins you as a responsible party to ensure that that particular operator has got measures in place to protect the personal information. But what we have done as a regulator, we had an engagement with the Public Service, PSC, Public Service Commission. And in our engagement with PSC, we had then said to PSC, they had said that they would coordinate. And one of the things that they had said they would do is that they would coordinate from a government perspective. They would ensure that even CETA is brought into the picture. I don't know whether, Mr. Mazibu, you remember the engagement, but they had said that they would ensure that they come back to us, but they still have not come back to us because we flagged these issues. We picked up that a whole lot of these security compromises was within the sphere of government departments specifically, and that is what we had then raised with them. I'll leave the issue of the broader participation to the CEO. And there is an issue around the independence of the information officer. Unfortunately, the scheme of things within POPIA says, and maybe there's a reason why POPIA had said that most of the information officers are at the level of CEO. The CEO of the regulator is the information officer, so that when the decision is taken, it is taken at that level. POPIA enjoins you, if you are an information officer, it says to you, all issues relating to compliance, you should ensure that you comply with the provisions of POPIA. And to the extent that the organization will then be saying to you, well, don't report the security compromise. When you are enjoined by Section 19(1) to report the security compromise, then you're going to be in hot water with the regulator, because as Mr. Luyaba in his presentation said, it makes it worse for you if you have not reported the security compromise. So you need to then go to the organization and say, to the extent that the organization would not be wanting to report the security compromise. When Section 19 enjoins the organization to report the security compromise, you must go to the organization and say, well, we have a responsibility, and if this matter comes to the attention of the regulator, then you may be liable and have to pay a fine of up to 10 million for not having reported the security compromise. I don't know whether there are, I think those are the questions insofar as POPIA is concerned. The other questions were in PAIA, and the other one I think was in relation to the compliance framework. So apology. The compliance framework, yes. The short answer to your question is yes. But you see, POPIA, if you read POPIA, POPIA is not going to tell you, it's not going to give you the solution. And the gentleman there was correct in the morning when he said, when you read the act does not tell you, give you a roadmap with regard to certain things that you must do and how you must do it. For instance, the act will say to you, reasonable measures. It will not tell you what those reasonable measures are. You have to look at the measures within the context of the business that you conduct and whether you've got standards, ISO standards. Mr. Mazibu knows the standards better. ISO and NIST, etc., etc. Now, the short answer to your question is the compliance framework. Even the compliance framework, it will not tell you what should be in the compliance framework. It tells you it's a set of policies, standards that you have to have in place to ensure that you comply with POPIA. So what we have done is that in order to make things easy for you, we've gone back and we've broken it down for you. We've said, here's a compliance, this is what we expect typically to see in a compliance framework. One of those things would be privacy policy. And the reason why you need to have a privacy policy is the privacy policy will tell you what is the personal information that you are processing, how are you processing that personal information, etc., etc. So to the extent that you would not have a privacy policy, you may be falling foul of the provisions of POPIA. So maybe the presentation when you get it will then give you a guide with regard to how to ensure that you comply with the provisions of POPIA. Thank you. No, I've already answered the fines. Yeah, National Revenue Fund. Yeah. We would love to keep the fines, Mr. Fortune. And we are in the process of trying to ensure that we keep the fines because we need it for our mandate. You know, coming here is a lot of money for the regulator, money that the regulator does not have. So we are trying, and it's for a noble cause. It's to ensure that you comply, because when you comply with the provisions of POPIA, it makes our life easy. Then those numbers that I had projected would go down because you would then be complying with the provisions of POPIA.
Mr. Sokela, on your question on the appointment of a CIO, I'm not sure where you're sitting. I didn't see. Okay, all right. Yeah, on the appointment of the CIO as a deputy information officer. So I think as Advocate just mentioned, each organization is different. The appointment of DIOs is then dependent on that organization based on what you do and the type of data that you process. So you may decide to appoint a CIO as part of the DIOs or the only DIO, but that's entirely up to the organization to decide. But you're right, everything is moving towards IT, so it makes sense to have a CIO as one of the DIOs. Thank you.
I normally wouldn't want to answer difficult questions. The reason is I'm paying colleagues seated here a lot of money. And that's the reason why they must answer all the difficult questions. On the COCTA invitation, we will really appreciate that we be invited very, very early and on time. You see, what normally happens is that people remember us 2 days before the meeting or a week before, and we have logistical arrangements to think about. We were in the Western Cape in November, December, and they said, come to COCTA MINMEC meeting. We would want you to talk to municipalities about issues of non-compliance. But we were invited, I'm sure, 2 days or 3 days before, and we could, luckily, during that visit, we had sent people to Cape Town, and we could only ask those colleagues who were in Cape Town to go and present. But as EXCO, as people who are in the leadership, if you want us to come, can we be invited on time? Because our diaries have a lot of other things that we do, and would really like to give respect to a MINMEC meeting by us coming. I would personally want to be there, and the executives would have to be there. So can we be invited on time? So we'll take on that. I think the CIO has dealt with the DIO question, but the ultimate responsibility of any decisions of access to information, of protection of information, lies with the IO, the information officer. And colleagues, it's becoming even dangerous these days. And today, the commissioner of police has gone to court in terms of the PFMA. Not that he participated in the whole thing. It's because he's the ultimate responsible person. Those decisions that are made, he has got to account for them. You can't run away from them. I normally say at the regulator that I have an orange overall ready for me. It's there, I'll go to prison. And sometimes I make unpopular decisions because I know that I'm the accounting officer. So sometimes colleagues become angry with me, say, oh, make this decision, do this. And I say, no, I don't do it. I refuse to do it because I'm ultimately going to take responsibility. When I'm in prison, my junior officials in my office say, CEO will bring you bread and milk. When you are there, I haven't heard the executive say, what is that they will bring? So whether you appoint a DIO, whether the DIO makes the correct decisions, the IO must take ultimate responsibility. And that's why the IO must register. And that's why the law says you can't perform any work around POPIA and PAIA without registering. Already, the IOs that have not registered in municipalities, the municipal managers, are breaking the law because they're appointing people on a daily basis. Appointment for work. You are signing and say, I'm appointing so. You are processing people's personal information. You are not registered already. There are serious problems there. And that's why we also need to go to that MINMEC and really alert municipal managers, MECs, mayors, and all of them that are breaking the law. They will love us one day because nowadays all of us are facing prison. The issue of accessibility of the regulator keeps me awake at night. It's true that at the moment we have got problems with issues of accessibility of the regulator because we've moved offices. We're in Braamfontein in Johannesburg, but we had to move to Woodmead. At the moment, I'm fighting wars on a daily basis to get those offices ready. That has had impact on accessibility in terms of telephones. We're trying to restore them now. Accessibility in terms of the state of readiness. We have got the Department of Labor that is now doing inspections on the building, and we have to ensure that the building is ready before people can come in. So I apologize for this, but you know, you've got to balance the two. You know, I've already received threats that I'll go to prison if I put people in a building that is not ready for occupation. So you balance that, but it's something that is true. I'm not going to stand there and deny it. It's true, it's a problem. We're going to see if we can resolve it as soon as possible so that people must access the regulator, so that the regulator can do its work. Lastly, the revenue fund is a big struggle. Advocate Bikanya's answer to it. Our funding is still through the funding model that is in section 52 of POPIA. We get appropriation through the vote and the political thing. It takes away our independence. We want to charge information officers like people do in other countries. I was in Zimbabwe in April. They are charging information officers. I've been to Europe, I've been to America, I've been everywhere. They are charging information officers so that the regulator must be an independent organization. Once you are funded by the state like we are, as things are, it's difficult to get an increase. We are operating with a budget of 130 million. 70% of that goes to salaries. About 30 million goes to Dikopan and all these activities. Can you imagine 30 million activities for the entire financial year? How we survive, I do not know. It's just that perhaps we're lucky because we've employed very, very good executives, very good technical people, and the Eastern Cape has also contributed. I mean, the Mazibus of this world come from here, the Luyaba ICT, advocacy, we have employed very good people, but they're going, we're losing them because other people pay them better. So we are worried about the revenue that we are supposed to collect and use. We still have to ask Treasury to reallocate. If you find people money, it must still go via Treasury, and sometimes they don't. They now give it to commissions. Thank you.
Thank you so much, CEO. We are terribly and horribly over time, unless all colleagues that are here who live here will accommodate us, because some of us are going to be late by flight. Thank you so much, colleagues. That was very much appreciated, the robust engagements. I do apologize for those that I didn't give an opportunity, but I do want to indicate that after we leave, anyone wants to have stakeholder engagement training sessions, we do have a capacity challenge, but you can speak to me. I'll share my email address. And and I think you are correct, Mr. Zenzile, as CEO said about the issue of accessibility. However, I just asked Daisy to reshare the cell phone number that we're temporarily using, that we are accessible on. So I think we need to keep sharing until our telephony system is up and running. So I just wanted to indicate that. And Mr. Akona, we do have a number of templates on our websites and guidance notes, and really, really easy step-by-step guides on certain developments of documents and how to process personal information. So please, I do invite you to visit our website, but also make these requests on our support services. Colleagues, it has been wonderful. I do apologize. Time limitations are against us. And I would like to invite everyone to join us for now, not breakfast, but brunch perhaps. But Amakandaya Banda, and I do not like cold eggs. So please, can I request everyone to just go down to the restaurant and join us for a short breakfast. Thank you so much, and do travel safely. Thank you for joining us.